Hello, this is for the University of Cumberlands ISOL 633. This is Chapter 4 for the textbook Legal Issues in Information Security. Identity theft is a rapidly growing crime. Consumer financial information is a goldmine for an identity thief. An identity thief can use this information to establish a new identity. Identity theft victims spend time and money repairing damage caused by identity thieves. Victims must repair their good name and their credit. Identity theft is a crime that can have a large impact on a person's financial situation. Consumer information is valuable and must be protected. In 2008, 285 million records were compromised in data breaches. The 2013 Verizon data breach investigation report stated that 37% of the incidents that are analyzed for the report affected financial institutions. Credit card data, 61%, and personal account credentials, 38%, were the top two types of compromised data. These attacks are most often opportunistic. This means that the victims aren't targeted. Instead, they were attacked because they showed a weakness that the attacker knew how to exploit. Individuals take many steps to protect their financial information. Banks and other financial institutions use this data when they conduct business with their customers. You expect these companies to protect your data as well. This chapter focuses on the laws and regulations that financial institutions must follow to protect the security and privacy of consumer financial information. So, the learning objective of this chapter: describe legal compliance laws addressing how financial institutions protect the security and privacy of consumer financial information. So topics we will cover include what the business challenges facing financial institutions are, what the different types of financial institutions are, what consumer financial information is, who regulates financial institutions, what the Federal Financial Institutions Examination Council is, what the Graham-Leach-Bliley Act is, what the Federal Trade Commission Red Flag Rule is, and what the payment card industry standards are. So, business challenges facing financial institutions. Financial institutions collect and use sensitive consumer financial information. They face many challenges in protecting this data. Consumers demand that financial institutions protect the data. They also want financial institutions to protect them from financial harm if this data is disclosed or stolen. Consumers aren't the only victims of identity theft. Financial institutions become identity theft victims when thieves use a consumer's financial information to do business with the institution. Identity thieves can open bank accounts in the victims' names and write bad checks. Thieves also can create counterfeit checks to use on a victim's account. They can take out loans on the victim's name. Many bank rules and regulations force financial institutions to bear the cost of many of these actions. A recent study estimated that these institutions paid $11 billion in identity theft costs in 2008. Financial institutions often get entangled in phishing scams designed to steal customer financial information. Many of these email scams appear as if they came from a well-known bank. These scams use the bank name and logos or other graphics to look like legitimate email. These scams cost the financial institutions money to investigate and respond to consumer complaints. Many large national banks and even regional financial institutions have had their names and logos used in phishing scams. Many post information on their websites regarding phishing scams. They post information consumers can use to tell the difference between real emails from the bank and phishing scams. Financial institutions are often the targets of hackers. The famous 1930s bank robber Willie Sutton, said that he robbed banks because that's where the money was. Banks and financial institutions will have plenty of money, but thieves no longer have to leave their own homes to steal. In 2009, hacker Ehud Tenenbaum pleaded guilty to fraud charges. He hacked into the computer systems of banks California, Florida, Indiana, and Texas. Some reports indicate that up to $10 million was lost due to his attacks. The financial industry is highly regulated. These institutions must follow regulations designed to protect the security and privacy of data that they collect and use. These rules place a compliance burden on financial institutions. So, types of financial institutions. The National Bank Act of 1864 established a national banking system in the United States. The Act still governs U.S. national banks, even though Congress has updated it many times since 1864. Many laws define the different types of financial institutions that are regulated in the United States. Most people know that financial institutions include banks and credit unions. These are organizations that provide financial services to customers. They include savings and loan associations, financial companies, insurance companies, and investment companies. Laws also define the types of organizations that are considered financial institutions. Different laws may use the term in different ways. For example, the Fair Credit Reporting Act of 1970 defines financial institutions as banks, savings associations, and credit unions. It also includes any organization that holds a transaction account on behalf of a customer as a financial institution. This law has a very specific definition. Consumer financial information. A consumer is a person who buys goods or services. Consumer information is the personally identifiable information that a person provides to get a good or service. In the financial industry, customers provide it to get services from banks or other financial institutions. People use it to get home or car loans, apply for credit cards, or open checking accounts. Items that a person buys for personal, family, or household use are called consumer goods. Services that a person buys for personal, family, or household use are called consumer services. These terms aren't used to refer to goods or services purchased by a business. Consumer financial information includes many items other than a person's name. They include social security numbers, driver's license numbers, addresses, and phone numbers. It can include work history if a person needs to provide it in order to get a loan. Consumer financial information also can include a spouse's employment and income history. It's all information that a consumer provides to a financial institution in order to get a product or service. So who regulates financial institutions? A number of different federal agencies regulate the different kinds of financial institutions. This section focuses on these agencies. These agencies enforce the consumer protection laws discussed later in the chapter. State governments may also regulate financial institutions. This chapter doesn't discuss that type of regulation. There are 4 federal regulatory agencies for U.S. financial institutions. These agencies make sure that the U.S. financial institutions are sound. An institution is sound if it's financially healthy and safe. These agencies also make sure that their institutions follow federal law. The federal bank regulatory agencies are the Federal Reserve System, Federal Deposit Insurance Corporation, National Credit Union Administration, and the Office of the Comptroller of the Currency. So the Federal Reserve System. Congress created the Federal Reserve System in 1913. The Federal Reserve Act of 1913 was passed to address financial uncertainty. bank and business failures would take a tremendous impact on the U.S. economy. The Federal Reserve Act was intended to provide the nation with a more stable economy. The Federal Reserve System is the central bank of the United States. Essentially, it's a bank for other banks. It's also a bank for the federal government. The Fed is an independent federal agency. It reports directly to Congress. The Fed is responsible for directing the nation's monetary policy and maintaining the stability of the U.S. financial system. The Federal Deposit Insurance Corporation. The Federal Deposit Insurance Corporation, or FDIC, was formed in 1933 to provide deposit insurance to banks. Congress formed the FDIC originally as a temporary government corporation under the Banking Act of 1933. The FDIC was formed in response to bank failures during the Great Depression. From 1929 to 1933, bank failures resulted in about $1.3 billion in losses to depositors. No depositor has lost any money in insured funds because of the bank failure since FDIC insurance began January 1, 1934. Congress made the FDIC a permanent federal agency in 1935 under the Banking Act of 1935. The National Credit Union Administration. Congress enacted the Federal Credit Union Act in 1934. That law allowed federally chartered credit unions to form. National Credit Union Administration, or NCUA, was formed in 1970. Its role is to charter and supervise federal credit unions. The NCUA is an independent federal agency. A credit union is a cooperative financial organization. Credit union can have federal, state, or corporate affiliations. Members of a credit union share the same affiliation. They might live in the same city or work for the same employer. The credit union is a non-profit institution that is run by its members. Members pool the money together at a credit union to save and make loans to one another. Office of the Controller of the Currency. The Office of the Controller of the Currency, or OCC, was originally established in 1863. The National Bank Act of 1864 is a law that authorized the OCC today. The OCC is a bureau of the U.S. Department of the Treasury. The OCC charters and supervises national banks and federal savings associations. Federal savings associations are also called thrifts. A thrift is an organization that accepts savings account deposits and then invests the proceeds of those deposits in home mortgages. National bank and federal savings associations are members of the Federal Reserve System. They are required to be insured by the FDIC. And special roles the Consumer Financial Protection Bureau and the Federal Trade Commission. The Consumer Financial Protection Bureau, or CFPB, was created in 2010. The purpose of the CFPB is to protect consumers in the financial industry. Unlike the Fed, FDIC, NCUA, and OCC, which regulate financial institutions directly, the Consumer Financial Protection Bureau focuses solely on consumers. The CFPB is an independent agency that ensures that all consumers have access to financial products and services. It also ensures that financial products and services are offered in ways that are fair and competitive. The CFPB has the authority to examine the financial institutions to ensure that the institutions are compliant with federal consumer financial laws. The Federal Trade Commission, or FTC, is an independent federal agency. Congress created it in 1914 under the Federal Trade Commission Act. Like the Consumer Financial Protection Bureau, the FTC, or Federal Trade Commission, is an important regulatory authority for consumer protection issues. The mission of the Federal Trade Commission is to protect consumers and make sure that business is competitive. It tries to eliminate practices that are harmful to businesses. The FTC has responsibilities under 46 different federal laws. Most of these laws include consumer protection elements. Federal Financial Institutions Examination Council, or FFIEC. Congress established the Federal Financial Institutions Examination Council in 1979. It's created by the Financial Institutions Regulatory and Interest Rate Control Act of 1978, also called FIRA. The Federal Financial Institutions Examination Council promotes uniform practices among the federal financial institutions. Its purpose is to establish principles and standards for the examination of federal financial institutions, develop a uniform reporting system for federal financial institutions, conduct training for federal bank examiners, make recommendations regarding bank supervision matters, and encourage the adoption of uniform practices and standards by federal and state banks. The FFIEC has 6 task forces. Representatives from each agency serve on each task force. Each task force includes at least one senior official from each of the agencies. First one is consumer compliance. This task force promotes a uniform approach to consumer protection laws and regulations. It develops proposed policies and procedures for the agencies to use in their regulatory activities. Examiner education. This task force oversees the FFIEC's intra-agency examiner education programs. Task force also develops specific programs to respond to requests from FFIEC or its members. Information sharing. This task force promotes sharing electronic information among FFIEC members, help them meet their regulatory responsibilities. Reports. This task force establishes uniform financial reports for FFIEC members. And supervision. This task force establishes supervision and examination procedures for FFIEC members. Its purpose is to help reduce regulatory burden by promoting effective supervision and examination practices. And surveillance systems. This task force develops systems to monitor the financial condition and performance of financial institutions. The Gramm-Leach-Bliley Act, or the GLBA. Congress passed the Gramm-Leach-Bliley Act in 1999. It's also known as the Financial Services Modernization Act of 1999. Law made great changes in the banking industry. The banks, securities, and financial companies to merge together. This wasn't allowed before the law. The financial industry urged Congress to pass the law so that customers could use one company for all their financial needs. The Gramm-Leach-Bliley Act allowed large companies to merge. These new, larger corporations would have access to sizable amounts of consumer financial information. People feared that their privacy would suffer as a result. This fear was not unreasonable. Financial institutions often sold customer banking information to other companies. To help alleviate this fear, Congress included privacy protections in the Gramm-Leach-Bliley Act. So the impacts of the Gramm-Leach-Bliley Act. The Gramm-Leach-Bliley Act applies to financial institutions. It defines financial institutions as any institution engages in financial activities. The definition of financial activity is very broad, includes borrowing, lending, providing credit counseling, credit collection, and other activities. Law requires financial institutions to protect the consumer's non-public financial information. It states that each financial institution has an affirmative and continuing obligation to respect the privacy of its customers. This means institutions must provide privacy and security protection to its customers. So non-public personal information, or NPI. NPI is personally identifiable financial information that a consumer gives to a financial institution. NPI also includes private information that an industry gets from other sources. It can include lists or descriptions of consumers that are prepared by using this kind of information. NPI can be in paper or electronic form. NPI, or non-public personal information, includes Social Security number, financial account numbers, credit card numbers, date of birth, name, address, and phone numbers when collected with financial data, and details of any transaction or the fact that an individual is a customer of a financial institution. The non-public personal information doesn't include publicly available information about a consumer. Publicly available personal information is available to the general public. It can be made public through state or federal records or disclosed as required by law. Information can be made public in different ways, such as records filled in a county records office. Financial institutions can't assume that certain types of personal identifiable information are publicly available. They must take reasonable steps to make sure the information is publicly available if they want to claim that it's publicly available. So the GLBA requires financial institutions to follow three main rules to protect consumer financial information: the privacy rule, safeguard rule, and the pretexting rule. The GLBA applies to consumer financial transactions. These are transactions made by personal, family, or household services. And the GLBA does not apply to business transactions. So the privacy rule. Under the GLBA privacy rule, a financial institution may not share NPI with non-affiliated third parties unless the institution gives notice to the consumer. The notice must tell consumers about types of data the institution collects, how it's used that information. This is called the Notice of Privacy Practices. GLBA also requires that consumers have a chance to opt out of some data sharing. The GLBA privacy rule went into effect July 1st, 2001. Congress gave the federal bank regulatory agencies, the Securities and Exchange Commission, or SEC, and the FTC the authority to enforce the privacy rule. Also must make regulations that support the rule. Congress required them to issue consistent regulations. All the agencies created and issued similar regulations. The safeguards rule. The GLBA requires the federal bank regulatory agencies, the SEC, and the FTC to issue security standards for the institutions that they regulate. This is commonly referred to as the safeguard rule. Law requires that each agency establish standards that protect the security and confidentiality of consumer information, protect against threats to security or integrity of consumer information, protect against unauthorized access to or use of customer information that could result in the harm to a customer. Congress didn't require regulatory agencies to work together to create these standards, as they did for privacy provisions. The federal bank regulatory agencies worked through the FFIEC to create joint guidelines. These guidelines were issued in early 2001. The SEC issued the standards in June 2000. The FTC issued its safeguard rules in May 2002. Financial institutions regulated by the FTC had to comply with this rule by May 2003. The FTC Safeguard Rule requires financial institutions to create a written information security program. This program must state how the institution collects and uses consumer information. It must also describe the administrative, technical, and physical controls used to protect that information. The program must protect information in paper and electronic form. And the pretexting rule. The GLBA's final consumer protection is the pretexting rule. Pretexting is trying to gain access to customer information without proper authority to do so. Pretexting also is known as social engineering. Under the law, it's illegal to make false, fictitious, or fraudulent statements to a financial institution or its customers in order to get customer information. It's also illegal to use forged, counterfeit, lost, or stolen documents to do the same thing. These rules try to stop identity theft before a crime is committed. Courts can impose criminal penalties if these rules are violated. Most financial institutions address pretexting in their information security programs. Discovered as part of the security awareness training activities, employees are trained to recognize and report pretexting. So again, we have the privacy rule. Financial institutions may not share MPI or non-public personal information with non-affiliated third parties unless the institution gives notice to the consumer. Notice must tell consumers about types of data institution collects and how it uses that information. And consumers have a chance to opt out of some data sharing. And again, the safeguard rule. Each agency must establish standards that protect the security, confidentiality of consumer information, protect against threats to the security or integrity of customer information, and protect against unauthorized access to or use of customer information that could result in harm to a customer. And then the pretexting rule. Pretexting is trying to gain access to customer information without proper authority. It's also known as social engineering. So it's illegal to make false, fictitious, or fraudulent statements to a financial institution or customers to get customer information. Illegal to use forged, counterfeit, lost, or stolen documents. And it's designed to try to stop identity theft. So the Federal Trade Commission Red Flag Rule. Congress passed the Fair and Accurate Credit Transaction Act of 2003, also called the FACTA, in response to growth in identity theft crimes. The Fair and Accurate Credit Transaction Act made it harder for consumer financial information to be used to commit these crimes. It also made changes to the Fair Credit Reporting Act of 1970. Congress recognized that the financial industry has a role in protecting consumers from identity theft. The Fair and Accurate Credit Transaction Act required the federal bank regulatory agencies and the FTC to work together to create rules that would identify and respond to possible instances of identity theft. These agencies issued a joint rule in November of 2007. The joint rule is known as the Identity Theft Red Flags Rule. So the purpose of the Red Flags Rule is to fight identity theft. The rules required covered financial institutions to be on the lookout for certain warning signs. These warning signs might include that identity theft is taking place in consumer financial transactions. The red flag isn't a data security rule. It doesn't require institutions to protect data in a certain way. Instead, it requires them to be flexible and responsive to different business situations where identity theft could be possible. The red flags rule applies to financial institutions and creditors and covered accounts. Financial institutions are state and federal banks, credit unions, and savings and loan associations. They are regulated by the Fed, the FDIC, the OCC, and NCUA. So the red flag categories. The first one is suspicious documents. Identification documents that look altered or forged. A signature on a document that doesn't match the signature in a customer's file. Or a photograph or identification document that doesn't look like the person presenting the identification document. Second one is suspicious personal identifying information. Personal information provided that doesn't match external information sources, for example, an address that doesn't match the customer's consumer report, incomplete personal information provided when opening an account, or another red flag would be personal information provided that doesn't match the information in the consumer's file. Another red flag is unusual account activity or suspicious activity. So examples are a covered account used in a manner that doesn't match the customer's historical activity, an unpaid account with no history of non-payment on that account, and frequent new use of a covered account that was unused for a long period. Another red flag is notice of identity theft. Customer notification to the covered organization about suspicious identity theft, or law enforcement notification to the financial institution or creditor about fraudulent activity. And then credit reporting agency alerts. So examples would be a fraud alert placed on a consumer report, a credit freeze placed on a consumer report, or a consumer report indicating a pattern of activity does not match the consumer's historical activity. So the payment card industry, PCI, data security standards, DSS. So Payment Card Industry Security Standards Council, or the PCI Council, is made up of representatives of major credit cards. Major credit card companies are also called credit card brands. Major brands are MasterCard, Visa, American Express, JCB International, and Discover. PCI Council isn't a government agency. It's a private industry organization. PCI Council was formed in 2006, created safeguards designed to protect credit card data. Any merchant or service provider who accepts credit cards must follow the safeguards. This list of security measures is called the Payment Card Industry, or PCI, Data Security Standard, or DSS. Most recent version of the DSS, version 3.0, was released in November 2013. Went into effect January 1, 2014, and merchants had until December 31st, 2014 to move to the new standard. So any merchant who accepts credit cards must comply with the DSS, or Data Security Standards. This means that they must implement and follow the Data Security Standard rules. Compliance is required by the credit card brands. Most of the credit card brands also require merchants to validate their compliance with the rules. This means that it's not enough for merchants to say that's compliant with the rules. Instead, the merchant must prove that it is compliant with the rules. Different merchant levels have different validation requirements. Credit card brands set these requirements. Visa requires its level 1 merchants to have an independent evaluation each year. They also must have a quarterly network scanned by an approved vendor. A level 3 merchant, which is a smaller merchant, level 1 merchant, has different requirements. Under the visa validation requirements, a level 3 merchant must only comply with an annual self-assessment form and have a quarterly network scan. So the PCI DSS controls and rules. The first one, control category, would be build and maintain a secure network. So the rules that apply to that: merchants must install and maintain a firewall and router configurations to protect credit card data. And the merchants may not use vendor-supplied defaults for passwords and other security measures. Next one is protect cardholder data. The rules for that are merchants must take action to protect stored credit card data, and merchants must encrypt credit card data while it is transmitted across public networks. Third one is maintain a vulnerability management program. To apply with that, the rules are merchants must use antivirus software that is updated regularly, and merchants must develop and use secure systems and applications. Next one is implement strong access control measures. The rules to comply with that are merchants must use need-to-know principles to restrict access to credit card data. Merchants must assign unique logons to each person with computer access. And merchants must restrict physical access to cardholder data. Next one is regularly monitor and test networks. To comply with that, merchants must monitor access to network resources and cardholder data. Merchants must test their security systems and processes regularly, and then maintain an information security policy. To comply with that, merchants must create an information security policy so they know how to administer those regulations. So in summary, consumer financial institution information is valuable. In the wrong hands, it can be used to commit identity theft. The U.S. federal government regulates how this information can be used. The private industry also takes steps to guard this information. These laws and standards work together to protect consumers from identity theft. Thank you.